Aggravated felony deportation relief. Aggravated felony is a term of art used to describe a category of offenses carrying particularly harsh immigration consequences for non-citizens convicted of such crimes. Regardless of their immigration status, non-citizens who have been convicted of an aggravated felony are prohibited from receiving most forms of relief that would spare them from deportation, including asylum, and from being readmitted to the United States at any time in the future. Yet despite what the ominous-sounding name may suggest, an aggravated felony need not be aggravated, or a felony, to qualify as such a crime. Instead, an aggravated felony is simply an offense that Congress sees fit to label as such, and today includes many nonviolent and seemingly minor offenses. This fact sheet provides an overview of aggravated felonies under federal immigration law and the immigration consequences of being convicted of an aggravated felony. What makes a crime an aggravated felony? An offense need not be aggravated or a felony in the place where the crime was committed to be considered an aggravated felony for purposes of federal immigration law. Instead, an aggravated felony is any crime that Congress decides to label as such. As two prominent immigration judges recently noted, numerous non-violent, fairly trivial misdemeanors are considered aggravated felonies under our immigration laws. What if a conviction occurred before the crime was labeled an aggravated felony? In most federal courts, a conviction for any offense listed as an aggravated felony is grounds for deportation, even if the crime was not considered an aggravated felony at the time of conviction. Are aggravated felonies the only crimes for which an immigrant can be deported? No. An aggravated felony is one, but not the only basis to deport immigrants convicted of a criminal offense. Removal proceedings may also be initiated against immigrants convicted of one or more crimes involving moral turpitude, a broad category of offenses that includes, but is not limited to, most crimes that qualify as an aggravated felony. What are the potential consequences of being convicted of an aggravated felony? Deportation without a removal hearing. Mandatory unreviewable detention following release from criminal custody. Ineligibility for asylum. Ineligibility for cancellation of removal. Ineligibility for certain waivers of inadmissibility. Ineligibility for voluntary departure. Permanent inadmissibility following departure from the United States. Enhanced penalties for illegally re-entering the United States. In the words of the Supreme Court, immigrants convicted of an aggravated felony face the harshest deportation consequences. As Congress ponders proposals to include even more crimes under the definition of aggravated felony, it must consider the extremely severe consequences that will result. The immigration laws include numerous provisions to ensure that criminals are not allowed to remain in the United States, yet also recognize that exceptions should be made in particularly compelling cases, especially when an immigrant's removal will create hardship for U.S. citizens. Once a crime is labeled an aggravated felony, however, deportation is all but assured and individualized determinations are rarely possible to make.